We would ask that the court admonish and rebuke Mr. Weinstein's statements, admonish him to make no further efforts to put such improper statements before the jury.
There was nothing improper about that question to the witness, Your Honor.
How does this witness have any knowledge of the state's desires about who they most want to get with regard to the 19 or so defendants that are indicted in this case?
Day 126 of the Young Thug YSL RICO trial was ridiculous. The state wasted the entire day going over tedious details about Mounk Tounk's plea agreement with his lawyer, all because Mounk Tounk says part of his plea deal was false in front of the jury. Here we are, like 9 months into this trial. State decides to waste the entire day. There is a few interesting moments with some bickering back and forth, so stick around for that. Hit subscribe. Here we go, boys. Thug on day 126. Got the plaid sweater on.
And then maybe you could write an email to Mr. Wright and copy everybody and ask the same thing and ask him to respond to everybody.
Yes, I sure will.
Thank you.
Which I think is
What I asked. Be done yesterday? It is.
Yes. Otherwise, I could have sent the email.
Correct. Yes, I assumed it would be done the way that I instructed.
Miss Love's already in some hot water for not doing something the judge asked, but it sounds like she's not 100%, so maybe she's sick or something.
Mr. Wright was identified by the state as a potential witness. That's when they indicated they subpoenaed him.
Right.
At the time that he became a witness, any correspondences relevant, germane to his testimony would have needed to have been turned over. That would have been their obligation. And so we shouldn't have had to ask for what we asked for yesterday. They should have turned that over automatically once he became a witness, known witness to them. They haven't done that.
Still believe, Your Honor, that we are entitled to get those emails if there's any
Which is why
material.
Miss Love can either share them fully or I can do an in-camera inspection.
What's going on? Why didn't Miss Love do anything?
May or may not be apparent. I would prefer the in-camera inspection.
Okay, well just get them
Yes.
gathered together and get them forwarded to the court, please.
I can't believe we're doing this, but Mounk Tounk's lawyer's back up on the stand. I don't know why we're wasting time on this. Think about how much money they've wasted on this trial. It's actually insane.
Are your only options to enter play, go to trial, or do you also have the opportunity or ability to request something different than either going to trial or entering a plea?
I don't care about this plea bullshit. Now they're showing his plea or how they sent him his plea or something.
But yes, did we have different legal options he could choose? Yes. But why he made the choices he made, that's something you have to ask Mr. Sledge.
And when you spoke about your client not having the resources to conduct a year plus trial, did you ask to withdraw from the case at that point?
I did not. That would come after he makes the decision of what choice does he make among his different choices. Because he chose to go forward with the plea, then we never reach the issue of that.
Or that you insisted on behalf of your client that the state changed in this final? Were there things? I don't mind any explanation.
I'm going to say yes, and here's the explanation. Almost all the things we asked manifested itself in iteration number 3. That was the version before version 4, which is the one that ultimately got executed.
Okay, I know Mounk Tounk said several times he tried to change his plea and everything, and this is false. Miss Love, you didn't want to change my plea. Does this really have that much impact? Jury saying guilty or not guilty? Now there's been a little bit of a break, and they're going over something that probably has no relevance to whether or not YSL will be found guilty or not guilty.
I understand that one of them is this number 4 that the state was proposing that he say
That he was saying.
that he, Sledge, had personal knowledge that YSL associates were planning to murder Donovan Thomas Jr. And that is not ultimately what number 4 said. But are you saying that
In response,
the defense wants redacted the earlier version of number 4?
yes.
Yes.
I'm as confused as everyone else watching. Let's see what Max Sharp says right here.
Way down the rabbit hole. The state, we don't need anything redacted if it's not being admitted into evidence.
Well, I think it is going to be admitted, or at least tendered for admission into evidence. And the reason that it is at issue is because Mr. Sledge said there were things that I absolutely wanted changed that didn't get changed. And this establishes that there were very material things that would have been beneficial to the state that got changed because Mr. Wright and Mr. Sledge requested that they be changed. So I understand why that is relevant.
So things were changed. That's what they're trying to show the jury. They did change shit, but did they change everything?
If these are going to come in, I would certainly think that we need an instruction that they're not to take any of this as factual because it's not, in fact, what he ended up agreeing to.
I agree.
Yes.
There's nothing that Mr. Sledge said, okay, this is my story, and then the state came up with these factual acknowledgments, and then Mr. Sledge was like, oh, well, you don't have that quite right. This is what the truth is. These were drafted by the state from looking at the discovery.
Okay.
So I would ask if we're going to let in, I'm going to say incorrect information that Mr. Sledge has never agreed to, and we're going to expose the jury to this. I think we need to be a little stronger with the instructions and say these were drafted by the state and not based on anything Mr. Sledge said. Because I've been doing this for a while.
I get your point. And y'all, this is why I had us come a half an hour early, is because 8:30 to 9 was when we were supposed to be figuring out what was coming in, etc. But Miss Love, are you not in agreement with redacting things that didn't ultimately come into the final agreement.
Correct? For the reasons that the court earlier alluded to.
Concerns with putting that type thing before the jury.
I was under the assumption there was something that Mr. Sledge said that led to the first statements, and then it was like an editing process. But the first version was not based on anything Mr. Sledge said.
Did you say earlier that that accurately reflects an email sent to you on December 27th?
I did. There were at least 4 versions. There might have actually been a little bit more, but when I'm looking at what I thought was the first version, which is what I thought my response was to.
What the am I watching?
All right. Are you able to say if there is any material change from the number 1 under the factual acknowledgement section from 452 to whatever version you're looking at that you think you might have been responding to? Just number 1 under factual acknowledgement. Number 1.
Okay. Number one's
Don't say what it is.
One is the same.
Okay. My only question relates to number 1.
Okay.
All right. And so as it relates to number 1 on the factual acknowledgments that you were responding to when you sent 460Y,
Mm-hmm.
is that number 1 the same as in 452Y?
Yes.
Is that the same in the document that has been admitted as 1AS in a prior hearing?
Yes.
And is that the same as number 1 on State's Exhibit 444Y?
All right, we already established that 1AS and 444Y are the same document, so you don't need to ask that question for all.
All right.
All the changes were ultimately incorporated. The only issue with the document is number 8.
Okay. Is there a material change to number 3 under factual acknowledgments that you requested but was not made?
3. Yes.
So there is something they requested that wasn't changed. And number 3.
Was there a material change to number 4 in State's 1AS that you requested that was not made?
No.
Was there a material change to number 5 in State's 1AS under factual acknowledgments that you requested that was not made?
No.
That Mr. Sledge requested that was not made?
No.
Was there a material change to number 6 of State's Exhibit 1AS under factual acknowledgments that Mr. Sledge requested through you that was not made?
No.
Was there a material change to number 7 under factual acknowledgments as reflected in State's 1AS that Mr. Sledge requested that were not reflected in number 7 on 1AS?
No.
Can you just say same question for number 7, same question for number 8?
Okay. Did you allow your client an opportunity to ask any questions that he needed to ask?
Yes.
Did you restrict his ability to ask you questions?
No.
If I speak to you in a normal speaking voice, can you hear me okay?
Absolutely.
I don't need to yell or shout.
You do not.
Okay. Proffer session again, I believe you said, is when a defendant meets with the state, correct?
Correct.
If there would have been a meeting between Mr. Sledge and the state, you would have been there, correct?
Yes.
Was there a meeting between Mr. Sledge and Attorney Love before December 27th?
No. Not that I have any recollection of. And I was, I never want to give an incorrect answer, so I was cautious. But I don't believe we ever actually sat down for a proffer.
Was there a meeting between Mr. Sledge and Attorney Hilton before December 27th?
No.
So there being no proffer sessions, I believe you received the first proposed plea agreement on December the 27th with a series of factual acknowledgments, correct?
Yes.
So how in the world, to your knowledge, did the state come up with those factual acknowledgments for your client to agree to without having met with your client?
Your Honor, I'm going to object based on relevance and speculation as it pertains to.
That's a great point. How did they come up with everything he knows or wants to agree to as the truth if they haven't met with him?
The state did something or came up with something.
Overruled.
I believe the state was trying to surmise through its overall
Well,
investigation.
now he asked your personal knowledge, so if you could answer that, please.
I don't have any personal knowledge how the state came up with these factual proffers.
So you don't know how the state put those words in your client's mouth.
Objection as to the characterization.
Sustained.
Oh, Weinstein's popping off here.
How many plea negotiations have you conducted in your career?
Definitely over 1,000.
God damn.
Do you get everything you want in that final agreement?
No.
And is this plea any different than the other pleas where you don't get everything you want?
No, it's not.
I have no further questions.
Your Honor, I have a motion as to part of that, but I'll ask it at the time that we break.
What?
Mr. Adams.
What motion you got, Miss Love? You ain't got no motion.
You have never seen, never received, and there is no signed proffer agreement.
Objection as
anywhere.
to
Sustained.
At the time that you come into this in 2022, you have knowledge that detectives with the Atlanta Police Department had previously charged him with Donovan Thomas's murder, then ended up dismissing the charge. Right?
Objection relevance.
Wait, whoa. So both Woody and Mounk were charged with Donovan Thomas's murder at one point? This has to be one of the worst investigations I've ever seen.
Overruled.
Yes, that's the point. I was aware from before, so when this occurred, it wasn't
I thought that was just the word on the streets. That was also the police.
really something new to me. I was already aware that there was some history.
The only way you get out of jail, if you're in jail without a bond, is you either the case gets dismissed, right?
Correct.
Or you negotiate some sort of plea or deal that gets you out of jail, right?
Correct.
Or you go to trial and you get acquitted, and that gets you out of jail.
Correct.
Mr. Sledge wanted to get out of jail.
I'm going to say this every video, but 60% of you aren't subscribed. Hit subscribe and hit the notification bell so you're notified when I upload.
He had been in jail for a number of months by the time you spoke to him, and he was anxious about getting out of jail, wasn't he?
Objection, asked, answered, and sustained.
He discussed with you his desire to get out of jail. True?
Objection, asked, answered, and it gets into attorney-client privilege. Yes, sustained.
Were you attempting to get him out of jail?
Yes.
You were in court previously when there was some discussion about what an offered plea is. Is that right?
Yes.
Now, and one of the ways that a defendant, Ms. Sledge, could resolve a criminal case is with what's called an offered plea, right?
Yes.
An offered plea, as you would have discussed with Mr. Sledge in one of his previous cases, revolves around someone saying, I'm not guilty of the charge, but I'm going to plead guilty because it's in my best interest. Is that right?
Correct.
So why this is being brought up is because Antonio took an ALFORD plea in 2015, maintaining his innocence, but he's taking the plea, obviously. But then the state wrote in their 2022 plea, he just pled guilty. They didn't add that it was an ALFORD plea in 2015. And that's shady as fuck.
And you would agree with me that entering a plea of guilty, whether it's under ALFORD or just a straight guilty plea, can sometimes be in a person's best interest, right?
Oh, absolutely.
And that may sometimes be regardless of whether they consider themselves to be guilty of the offense or not.
Objection,
True?
non-relevance.
Correct.
It's very relevant, Miss Love. This has been brought up several times. What are you yapping about? I hate her.
Mr. Sledge did not have the resources to go to trial.
Correct.
And it is true, as you testified. Did you hear testimony about that?
I did.
And did you testify also earlier that you knew that he had limited resources and he just didn't have the resources to take this case to a year plus trial, right?
It was something that was heavy on my mind in terms of when I'd be able to return to practice, to be able to assist Mr. Sledge.
Because the plea was entered on December 28th, true?
Correct.
All right. The correspondences that were shown to you, well, we've been using the word iterations of this so-called plea agreement. The first one came to you on December the 27th, isn't that right?
Yes.
And so the very first time that you and or Mr. Sledge would have had an occasion to consider the state's proffered plea agreement was one day before he entered his plea. True?
Yes, and to give you detail,
Doesn't seem like a lot of time to make that decision.
that day, I actually, once I received it, went to see him to go over it. And then ultimately, it's when I got back that I sent the response. So that's why you can see I received it around 5 or so in the evening. I didn't respond until about 8 or so at night because I needed to basically go talk to him.
So we're talking now about maybe 4 or 5 o'clock p.m. on the evening of the 27th is when you first received from the state this plea agreement that they had drafted up, right?
Correct. That's the first one.
Right. And again, this plea agreement that they sent to you with the different paragraphs and provisions was something created by them, not by
Objection,
Mr.
Your Honor,
Sledge.
asked
True?
and answered. Sustained.
And when you went to the jail to meet with Mr. Sledge on the 27th, this would have been the first time that he had any opportunity to look at anything called a plea agreement. True? You would have discussed this plea agreement with him. True?
Well, again, not specific communication with Mr. Sledge, but with all my clients.
But hanging in the air at that time, with the plea agreement on one side and potential trial on the other side, was his concern about getting out of jail to see about his sick mother. True?
Objection, asked, answered.
Sustained.
Also hanging in the air was the possibility of him not having the resources to go to trial.
Objection,
Right?
asked, answered.
You had the opportunity to discuss with the state that there was a factual allegation in their plea agreement that you did not want or you wanted changed. Remember that?
Correct.
Video, where Mr. Sledge was alleged to have been in a video, holding a gun, making threats to someone else, to another person, correct?
Correct.
When the state presented any of the iterations, including that last one, right, of the plea agreement, they wanted Mr. Sledge.
Objection as to what the statement wanted.
The factual acknowledgement revolved around Mr. Sledge acknowledging that while associated with YSL and to support and express loyalty to YSL, the defendant, that would be Mr. Sledge, and co-defendant Demetrian Garlington and Quindarius Zachary appeared in the video with another person, AS, wherein defendant brandished a weapon used in a drive-by shooting and wherein on behalf of YSL, defendant threatened to harm a person named Kel, a rival gang member who had begun a relationship with defendant's ex-paramour, girlfriend. That was the factual acknowledgement, correct?
That was the factual acknowledgement.
You communicated with the state and you requested that they change that, correct? Or that it be removed.
Your Honor, objection is to compound, and I don't sustain.
You formed, or you observed, that the state was just as interested in getting this plea done as Mr. Sledge was. Isn't that true?
So objection. Yeah. Objection. It calls for speculation about the state, and whatever his observation is or belief was is not pertinent to any material.
Sustained.
Was it your observation that the state wasn't really concerned with Mr. Sledge and really wanted Mr. Williams?
Same
Sustained.
And I have a motion as well as to that.
What are these mysterious Miss Love motions here? So here's one of her motions. She doesn't like what Weinstein said.
But specifically, the comment that Mr. Weinstein made to which the state objected was, you don't know how the state put those words in your client's mouth. And my objection that the court sustained, obviously, is that it was an improper comment, improper statement put before the jury. And even though the court sustained it, Mr. Weinstein and others' ongoing efforts have been to spin a narrative that the state has forced something on one of the witnesses or more of the witnesses. But those particular words, Your Honor, that you put this, you don't know how the state put those words in your client's mouth. It amounts to Mr. Weinstein making a statement, not asking a question, and him making an assertion that the state, in fact, did something he did not do, which was put those words in your client's mouth. Everybody's heard the testimony and seen what happened. It was an improper statement in front of the jury. And it could be construed by the jury as something, notwithstanding any court's instruction, that they could take as fact. We would ask that the court under 17-875 admonish and rebuke Mr. Weinstein's statements and admonish him to make no further efforts to put such improper statements before the jury. My second motion deals with Mr.
Let's take them one at a time. All right. Yes.
Let's see what he says.
There was nothing improper about that question to the witness, Your Honor. I was inquiring about the facts. I'm sorry, I'm losing the word, but the facts that were put forward that the state created. The state doesn't deny that they put those together and gave them to Mr. Wright's client without any input from Mr. Wright. I think it was a proper characterization and it was a question. So the witness could answer that, just as Attorney Love has said. All the evidence is out there. It's all before the jury. The jury can draw what they want from that evidence. So there was nothing improper about that.
All right.
And actually, well, that's all I'll say.
Okay, so I think it was a mischaracterization. It was in the form of a question, but I believe it was a mischaracterization because if we had been talking about the final version that Mr. Sledge adopted, that might have been a fair statement to say, you know, they were put in his mouth, but these were not things that he ultimately adopted, so the state wasn't putting those words in his mouth. So I think it was a mischaracterization. It doesn't go so far as to warrant an admonishment before the jury, but let's try to be careful in our characterizations even when we are asking questions, all right?
Yes, Your Honor.
Sounds like the judge is not going to rebuke or admonish Weinstein.
That the jury heard. Isn't it true, and I'm going to paraphrase, that you knew that the state didn't want your client, the state wanted Mr. Williams. Mm-hmm. That's been the lie that the narrative that has been promoted from the start. We don't agree with it or adopt it, and we certainly don't agree with the idea that we do these things without a basis for them. So in as much as Mr. Adams made that assertion in front of the jury, we do believe that that merits an admonishment and rebuke under 17-875, and we would ask that the court give him one.
All right. And yeah, that statement was essentially, it followed upon another question that was not as objectionable in this way, but that had been sustained. And Mr. Adams, she pretty much doubled down on it and said something to the effect that the state wasn't interested in getting Sledge, they were interested in getting Williams. And that's inappropriate to have asked that witness. And I don't know why you thought that there was any basis for that being an appropriate question, because it would call for speculation anyway. So what's your response to the state's request that you be admonished with regard to that?
It was a question that I believe was an appropriate question, given the context of both this witness's testimony and his client's testimony previously. What we heard in the narrative that has been put forth, and quite frankly, I believe the evidence has been that the state has been mostly interested in Mr. Williams as a defendant as opposed to the co-defendants, particularly as regards this witness and Mr. Sledge. This meeting that they had on June the 9th, where the statement is made that is beneficial to Mr. Williams. Thought about him advising Mr. Copeland or Mr. Sledge to take Mr. Copeland to the police. And that's left out of any questioning of Mr. Sledge. He is asked, or he is, however, there's no discussion about that. We're not going to ask you about that, whatever portion of it you choose to believe. And so there is this narrative that's out there that they appear to be interested in Mr. Williams, not so much in the co-defendants. And the fact that all of the co-defendants who took pleas were asked, made, or signed plea agreements, the bulk of the plea agreements made specific reference to Mr. Williams. Mr. Williams as the head of YSL. Mr. Williams did this. There is this narrative out there that and everyone has gotten probation. All of the people that the jury has heard from has gotten probation after they were denied bond and the state took a harsh position that they didn't need to be out on the street. But the minute they entered pleas, and implicated Mr. Williams in some form of fashion in their plea agreements, then they were released. And so that narrative is out there, and I think that was an appropriate question to ask of this witness who has some knowledge.
How does this witness have any knowledge of the state's desires about who they most want to get with regard to the 19 or so defendants that are indicted in this case?
Because he is a defense attorney representing one of the co-defendants who entered into assisted in entering into a plea agreement. He is familiar with the discovery. He made a statement in part of his testimony previously that he knew what the case was about. And he started going down the road of talking about Mr. Williams before there was an objection made and the objection was sustained.
Judge might be a little mad here at Mr. Adams for asking that.
He does have knowledge of that. He knows about the case. He knows that Mr. Williams is alleged in this indictment by the state's narrative to be the head of this YSL organization, and he knows that the plea agreements have been to the benefit of the co-defendants who have pled and to the detriment of Mr. Williams.
And every other defendant still on trial.
Where the statement was made that we're interested in anyone who wants to make a deal, except Mr. Williams, we're willing to make a deal. And so he knows it. We're not doing this in the blind.
That's actually a good point. I remember seeing on Twitter years ago, one reporter that was in the courtroom, they're not giving Thug a plea deal unless he's in jail for life. straight up, basically saying everyone else could get out of jail but Thug.
I don't know of that statement that Mr. Adams is speaking about, except Mr. Williams. If he could point me to something, because I wasn't there when she said it. I wasn't even on the case, but I doubt she would say it. But if she did, I mean, I can't speak to that. I'd like to see it since he's made that assertion.
I don't believe, Mr. Adams, that there was any kind of a good faith basis to ask that question, and to think that was a proper question for this witness to be able to answer.
The judge doesn't like it. Is she going to rebuke and admonish him?
Ms. Lev, with regard to what you propose as any kind of curative or admonishment, I mean, I don't know what that would be.
I would ask that the court admonish Mr. Adams in front of the jury that the statement he made regarding the intentions of the state as they relate to Mr. Sledge and Mr. Williams were improper statements by counsel. Then those types of statements, the jury is to remember they are not evidence, but that Mr. Adams should not have made that statement in front of the jury.
There was an objection made, and the court sustained that objection, and I abided by the court sustaining that objection. This does not fall under the act of 17-875. This is not tit for tat where because Ms. Love was admonished previously, now she's trying to find every opportunity to get somebody else admonished. That's not what this is.
That's what I was thinking. I was like, since that happened to her, she's trying to get one for the defense.
I'll abide by the court's ruling, by the court sustaining the objection, but I've stated on the record what my belief was and what my good faith basis was for asking that question in regards to the narrative being put forth at the beginning of this case, and I'll stand by.
All right, Max, start up for cross.
A portion of a certain factual acknowledgement that you and your client disagreed with and bringing it to the attention of the state, correct?
Yes.
Well, you mentioned several, but there was one in particular that the state changed for you, correct?
Yes.
Okay. You received discovery, correct?
Yes.
And you were able to see what your client may have said or did not say to any police officers.
Correct.
Okay. And certainly you were representing your client and are aware of what your client may have said or didn't say to any district attorneys. And you would be aware of what your client would have said to any district attorney investigators, correct?
Yes.
Okay. The part of factual acknowledgement number 8 that you asked to be removed, and the state removed it, okay? You with me?
Yes.
The state removed it, do you agree?
Yes.
Okay. That part that you asked to be removed, from your review of the discovery and from representing your client never said such a thing, correct?
I can say that my client never said or adopted that statement, and that was one of the reasons he asked it to be removed.
Okay, and I understand he didn't adopt it, but to your understanding, he never said it.
Correct.
Okay, and that's why I'm just trying to clarify. That portion that you asked to be removed is not something that your client once said and is now disowning or saying he's changed his mind. It's something that was never said.
Objection asked and answered twice.
That's correct.
In the negotiations with the state, your client pled to count 1, which was conspiracy to commit RICO violation, correct?
Yes.
He was sentenced, the agreement was 15 years to serve on probation, correct?
Correct.
And in count 30, he's facing on count 30 is 15 years, correct?
Yes.
And so his maximum exposure is 15 plus 15, correct?
Yes. I mean, technically less, we'll say any time is already ticked off since the agreement. But generally speaking, it's 15 plus potentially another 15.
There was one factual acknowledgement that you testified you missed, correct?
Correct.
Number 8 on the final agreement you missed.
Correct.
That your client, while associated with YSL and to support and express loyalty to YSL, made this video. The acknowledgement indicates that the video was made on behalf of YSL, correct?
Correct.
Okay, and you pushed back on that and you sent Ms. Love an email, correct?
Correct.
This email was sent on December 27th at 8:43 p.m., correct?
Yes.
Okay, this is the night before Mr. Sledge entered his plea, correct?
Yes.
You wrote regarding number 3, the video may have seemed like the issue was gang related, but it was actually about a girl that Sledge was dating and Kel started kicking it with her. That was the real issue behind that. Not denying the video, but the issue was the girl. Is that what you
Yes.
wrote? And is that verbatim?
Yes, that was verbatim.
Okay, so the point you were trying to get across is you're not denying that your client, Mr. Sledge, made the video, and you're not denying that he had an issue with Kel, but that issue was about a girl.
Yes.
Ultimately, the state was unwilling to change that factual acknowledgement in the plea agreement, correct?
Correct.
They were unwilling to take out that it was done on behalf of YSL.
Correct.
This is really good for him to get this out in front of the jury. They're unwilling to take that out, forcing it that it's about YSL and not a love triangle.
I believe on cross, you indicated that in negotiations, you can't have everything, and sometimes you have to live with some things, correct?
Correct.
And your client initialing number 3, even though he didn't completely agree with it, is an example of having to live with things, correct?
I think I previously did state that number 3 was an example where there wasn't a complete meeting of the minds.
To go home, Mr. Sledge would have to live with that. It's part of the negotiations, correct?
Objection, Your Honor. Asked and answered.
Sustained.
Is it fair that Mr. Stillwell would have to live
Objection,
with your
Your Honor. Asked
client?
and answered.
No.
I'm sorry, that is not what I'm at. Objection, relevance, and improper question. Is it fair that Mr. Stillwell have to do anything is an improper question for this witness? So give me
Sustained.
Was Mr. Stillwell a party in these negotiations?
objection. That is, again,
He's just trying to point out the fact that all this nonsense with the plea, now Shannon Stillwell is the one taking the L for it at trial.
Was your client signing a factual acknowledgement that wasn't true? Is that something that Mr. Stillwell should have to live with?
objection. One.
And he initialed it and he got to go home.
Objection.
And it affects these other gentlemen back here, correct?
Sustained.
No further questions.
All right, Miss Love's up on redirect with the lawyer, and none of this really matters in the long run.
The portion that says where a defendant brandished a weapon used in a drive-by shooting is incorrect, inaccurate, or false.
The answer is no. And further, again, we took no issue with the video. The video is what it is. The issue was just, we were saying sometimes what the motive was. The motive was a girl-related motive, not YSL. Yes, he may be YSL, and yes, the video, he does.
Hang on just a second.
Did you ever indicate on behalf of your client in any fashion, whether in 460 or some other way, that the portion querying on behalf of YSL defendant threatened to harm a person named Kale was false?
No.
And to not split hairs, but did you at any point say in your email or anywhere else that that part is factually incorrect?
No, but also understand, my email came the day before. As we started getting into these later versions, I was here in court. I wasn't sending emails. At that point, we were communicating verbally back and forth because we were sort of both here. So but the point being is, that was something that my recollection is, hey, we changed it to the extent we're going to change it, and that ultimately we weren't going to change it further or, eliminate that.
So Miss Love's going through everything in the plea that they never asked for it to be changed. Basically trying to show the jury that everything that they didn't want changed is the truth.
Am I correct that you said number 3, you asked to be changed and it was changed, but not exactly like you wanted? And then number 8 was one that you said today that you missed back at some point when you were reviewing the document.
That is correct.
Wait. I missed that earlier. The part in the plea where it says defendant has personal knowledge that members of YSL killed Donovan Thomas. He missed that. What the f***? What type of lawyer misses that in a plea agreement?
I said today that number 8 was missed, and a review of it versus our earlier, they can't be reconciled. I mean, in other words, it's clear that that was not something that we would have anticipated. In other words, it was something we objected to and wanted removed. Ultimately, it reappeared in that final version. We did sign it. Again, I'm not taking issue. We missed it. Unfortunately, had I seen it the day of, I would have paused, stopped everything, and said, this is a hard stop. We got to figure this out.
Outside of what's contained in the final 1AS, is there any other thing that you asked the state to change that we did not?
Ask the answers.
That was also the last answer. I do. Okay, we'll move forward.
Max Sharp is giving Miss Love a taste of her own medicine there with all the very annoying objections interrupting everything.
How we missed it, how I missed it, I don't know. But apparently, I did.
All right, Mounk Tunk's lawyer's done. I hated every second of it. This guy is some sort of representative for the car Infinity. Like, I guess he's just going to testify about the Infinity that was used in the murder of Donovan Thomas.
Can you describe for the jury what stands out to you in terms of it is different about the Infinity Q50 compared to other Infinity makes and models?
Just the shape of the tail lights are a little different than some of the other models. They kind of mirror the headlights where they're kind of a little more kind of sunken into the body of the car.
Do you all have certain naming conventions for the colors that the cars may come in?
Yes, this particular color is diamond graphite.
So they're showing the outside angle of when Donovan Thomas got shot. I'm not gonna be able to show any of it because even when I blurred it in my last video, YouTube age restricted and killed the entire video. So that's the clear shot they got of the car right there of the Infinity pretty much.
What is your favorite physical attribute of the 2014 Q50?
I'm going to object that to
Sustained.
I would too, Your Honor. That's why with that said, Your Honor, the state does not have any more questions.
What the f was that last question? Keith Adams up for cross.
Do you have any personal interaction with any car, any Q50 that would have been brought into your dealership back in January or February of 2015?
I wouldn't be able to recollect that.
And you would not have been the one to observe or look at or inspect any vehicles brought in from birth. Anyway, would you?
Only thing I would do was check it in, which basically would mean getting the mileage, VIN plate off of it, and doing like a walk around for damage. That would be my end as far as inspection.
Would you agree that was a black and white video?
I don't know if I would classify it as black and white. It wasn't the greatest of quality of video, but I would say it was black and white.
Okay.
I can tell it's a grayish color. I mean, just like the car that's behind the white one appears to be like a reddish color.
You're not a scientific expert, right?
No.
You've never been qualified as an expert in Infinity's identification of vehicles, true?
No scientist, no.
Okay. You've never been qualified in a court of law as an expert in identification of vehicles.
Never been to court before or anything for it, but as far as an expert in knowing Infinities, I probably would say yes, I know all of them.
Tell me whether or not that vehicle that you're looking at, the one that you identified as an Infinity Q50, has standard size wheels or non-standard wheels on it as you described earlier.
We're talking about the screen, not the picture, right?
Talk about the screen.
I think you can barely see the wheels from this
All right.
So he's just picking apart the image and how terrible it is, and it is pretty bad. Like, you can barely tell it's the same vehicle.
And Infiniti emblem or insignia on the front grille.
This one doesn't capture it. They tried to roll it forward so where you can see that there is something silver in it, but technically they couldn't get stopped at the right time.
That emblem on the grille that we can't see on the video, right?
250, yes.
Every 250 has that emblem on the side that we can't see on the video, right?
Correct.
Every Infiniti has maybe standard, maybe not standard wheels that we can't see on video, right?
Correct.
But your testimony to this jury is that these pictures given to you by the state, the same vehicle that's on that video.
Correct.
All right, that's all.
All right, that's pretty much it for day 126. Pretty terrible. I mean, why waste this much time on the plea deal bullshit? I don't know, dude. Join the channel membership. It's only 10 cents per day. I really appreciate the support. I love you guys. Hit subscribe. Peace out.